Welcome back to the Making International in Korea video series. In this video, I will touch upon the core principle of sovereignty and its implications for international law, especially as it relates to the implementation of international law into the domestic legal system of states. Let's say domestic implementation of international law. The sovereignty jurisdiction is a very important term in international law, and also it directly related with the national law. Let me first touch upon the sovereignty and jurisdiction. Two of the core principles of international legal system, the sovereign equality of states and non-interference in the internal and external affairs of the other state, have important implications for the issue of jurisdiction and its application within international law. The Westphalian sovereignty gives state the power to wield authority over all individuals residing in the state territory. This authority entails the jurisdiction to prescribe rules that are binding upon the individuals and state instrumentalists belonging to the state, and also, under certain circumstances, upon individuals abroad. It also entails the jurisdiction to settle legal disputes through binding decisions or to interpret the law with binding force for all the persons and entities concerned. Lastly, it entails the jurisdiction to enforce using coercive means so that legal commands and entitlements are complied with. The existence of a Westphalian sovereignty in the form of statehood also entails the related principle of non-interference. The states are prohibited from interfering with the international organization of another state. It also prohibits states from encroaching upon the internal affairs of the foreign states, along with prohibiting states from interfering in relations between foreign governments and their own nationals. Given this, the jurisdictional realities of the sovereignty emanating from sovereign equality of non-interference. Sovereign equality and non-interference. The rights of the immunity of foreign states from the jurisdiction of the foreign states delineate legal boundaries of the courts and other legal institutions. The very important principles, the sovereign equality and non-interference, you have to remember all the time when you apply the international law, any case we are dealing with. The states are not permitted to interfere with the public acts of the foreign sovereign states out of respect for their independence. For the judiciary should not interfere with the conduct of foreign policy by either national or foreign government authorities on the principle of the separation of powers. As summarized by the very important case, the United States Supreme Court in Underhill Hernandez case in 1897, the case referred, every sovereign state is bound to respect the independence of every other sovereign state, and the courts of the one country cannot sit in judgment on the act of the governments of another done within its own territory. In other words, the act taken in a capacity as a foreign sovereign are immune. Let me move to the civil jurisdictions. However, in relation to civil matters, almost all states have a view of restrictive immunity. Just in many states, the private or commercial transactions of states are subject to domestic court jurisdiction, and foreign sovereigns are also likewise being subject to jurisdiction of domestic courts. We have to distinguish that the civil jurisdiction and international jurisdictions. According to Lord Danning in UK, in all civilized countries, there has been a progressive tendency toward making sovereign liable to be sued in his own court, for his sovereigns should not be in any different position. Let me touch upon the next topic of international law and national law. Given the international legal system has its own set of rules with its own institutions that is set apart from national or domestic legal system, the issue arises as to what the relations is between the international legal system and domestic legal system. How that issue is addressed along with the questions related to the implementation of international law into the domestic legal system depends in large part on what perspective one has in regard to the connection between these two areas of law. There are actually two basic prescriptive approaches, which is the monoism and a dualism, which are the extremely insofar as no state has completely adopted one approach over the other, but rather states lean toward either one approach or the other. Among the two basic descriptive approaches, let us touch upon the monism first. This description of the relations between the international law and domestic legal system view all legal orders operating within a unitary, pyramidal legal order. Under a monism, international law is at the top of the pyramid and validates or invalidates all the legal acts of any other legal system. Consequently, in such a system, national law must always conform to international law. Further, the implementation of the international law into states' domestic legal system is not necessarily, since international law is already part of the domestic legal system. Therefore, domestic courts can and should use international law where it is relevant. Exceptions are made for the countries with constitutions that may require domestic courts to apply only statutes enacted by the national legislature. Courts may have to apply statutes that are contrary to international law. However, states are responsible for this non-compliance with international rules. I have to repeat this statement again. The states are responsible for this non-compliance with international rules. The second one is the dualism. In contrast, dualism describes the relations between domestic and international legal system as separate and discrete entities, each with its own power to set the effects of any outside rule of law might have within it. International law is generally not thought to be able to make itself effective in a domestic legal order. It depends on the constitutional rules of the domestic legal system itself. The dualist perspective carries a different assumption than monism in relation to the subject of the law, the sources of law, and the contents of the law. The domestic legal system deals exclusively with individuals and groups of individuals, for example, corporations, while the international system concerns itself largely with states. In terms of source, the law in domestic system can be found in legislative enactment, administrative regulations, and judicial case law, for example, in a common law system, and constitutions and other sources that come from within the states, while a source of international law include treaties, customary law, and general principles. Further, the content of domestic law regulates the functioning of the state and relations between states, and individuals, while international law governs the relations between sovereign states. Let me move to the implementation of international law. How a particular state implements international law with its domestic legal system is depend upon the internal working of the states and its approach toward international law. In certain circumstances, international law can be automatically incorporated into a state's legal system without the need to enabling legislation, while in other situations, international rules can only be effective if there is an implementing statute passed by the legislature. For example, the custom international law is typically automatically implemented into a domestic legal system through the application of judges in cases where it is appropriate to do so. You may remember this one is always happen in domestic legal system, but this is the case since the legislative branch is a political branch of the government. It is not equipped to identify customary international law and apply it. On the other hand, the judiciary has the expertise to find appropriate customary international law and also can apply it directly to a case at hand. With regard to treaties, the state implements their terms either automatically, for example, self-exacting treaties in the United States legal system, or the certain extent of the in civil law systems, or through implementing legislation by the legislative branch. These issues of treaty implementation are usually resolved through the constitutional law of a particular state. How the state rank international law when compared to domestic law. Some states within their constitutional order provide that the customary international law has a rank higher than domestic law. These include the monist leading states such as Italy, Germany, Japan, and Greece, and among others. Other states give customary international law a rank equal to that of ordinary legislation, such as the United States. With respect to treaty law, many countries treat law as higher than ordinary domestic law, such as France, and former French colonies such as Ivory Coast, Greece, Russia, Bulgaria. And in other countries, the treaties once incorporated into the domestic legal system have the rank of the ordinary domestic law. Thus, a latter law in conflict with the treaty provision incorporated is seen to be intended by the legislature to appeal the law, implementing that treaty provisions. You may see that the how difference in terms of the treaty and customary international law when it implemented in domestic legal system, how its application and interpretations can be made in terms of the difference of the domestic legal system. I'm going to give you the wrap-up of this week's video series. Unlike domestic national law, international law has different sources. Where law came from in a domestic legal system can be determined by the form of governments a particular state has. In many states that have a constitutional democracy and constitution of the country is a source of the law, along with the statute enacted by the legislature. In some countries with a strong executive branch, administrative regulations issued by the executive agencies is a very important source of rules. In countries that follow the common law, the judiciary makes pronouncements of what the law is through judicial decisions that are reflected in case law. In a domestic legal system, the common characteristics found in relation to domestic source of law, when viewed in light of the positivism, is the identification of the authorities that makes the law along with the presence of a hierarchy between domestic law, along with the related issues of which institution can prescribe, adjudicate, and enforce of the rules. As such, domestic legal systems have a particular orientation of legal authority. In contrast, because there is no formal legal authority of states, such as world government, the basis for international law is state consent. This gives the international legal system a horizontal orientation of rules that is created between sovereign equals. Accordingly, the source of international law can be found from the lawmaking actions of the state themselves. While in international domestic legal system, the law emanates from a sovereign is applied and enforced toward legal persons. In the international legal system, the source of rules is derived from the sovereign state, who are both the source and object of international law. International law are the rules that govern the activities of states between them. For the International Court of Justice, the principal legal organ of the United Nations, the law which it applies in settling disputes between states include international conventions, international custom, and general principles of the law recognized by the civilized nations pursuant to Article 38 of the Statute of the ICJ. Given that the consensual actions taken by states are the primary basis for the international law, the two principal sources of international law are international conventions and international customary law. International conventions or treaties are international legally enforceable agreements between states, while international custom or customary international law is made up of consistent state practice and often uses a sense of legal obligation. The state action in the form of treaty making and the state practice elements of international custom confirm the sense that international law are products of sovereign will. As such, the source of international law have been largely explained within the context of legal positivism, and in that international law is created by a sovereign state to govern their own actions, as opposed to an early understanding that international law was derived from sources apart from state, such as natural law.